When do injured workers typically get offered a workers' compensation settlement? At what point in their case does it happen? So, a lot of times insurance companies will make an offer, but more often than that, they will reach out to see if we have interest in settling. Insurance companies don't always like to throw out the first number. They like to get the first number. It's kind of negotiation 101. Most of the time, we're going to get a call or an email from an insurance company saying something along the lines of, please find out if your client's interested, and if your client is interested in settling, what's their demand? So a lot of times it comes as a demand from us. If we get that letter or that phone call, I'll reach out to my client and I'll say, hey, the insurance company's talking settlement here. They want to know what you want to do. And if my client is interested, we will work up a demand and send the demand over to them and start that process. It could come at any time. It could come under any set of circumstances, and it's really case specific and fact specific. I've gotten settlement offers on cases before the first hearing. Sometimes if it's a very complex issue, and it could go either way as to whether or not this particular case and this particular injured party would be covered, sometimes the insurance company is going to say, hey, you might not win this case. Here's X amount of dollars, and you could just walk away from this thing. So sometimes that happens up front. And we might look to settle a case like that. If I feel as though the facts are not great, and it might not be a workers' comp case, sometimes you could settle those cases as well. If a case has relatively minor injuries, sometimes an insurance company is going to say that there's no point in us fighting back and forth forever and ever over what are relatively minor injuries. Let's try to figure out the value of the claim, the value of the injuries, pay it, and we could all be done with it. And sometimes you can get a little more than what your injuries might be worth because you're saving the insurance company so much money in litigation costs. When it comes to minor cases and questionable cases, we look at those that we call those nuisance value cases. Sometimes we try to get whatever we can to just get rid of the case and move on. But it could also be on bigger cases. We had a case, a gentleman fell on a construction site, fell into a trench. He had shoulder issues, he had knee issues, both required surgery. And the insurance company said, these are our defenses here. This is why we're fighting this case. But they came up with a pretty good initial offer. And they said, we'll give you a guy, I think it was $75,000. And it was very tempting for my client, but he needed surgery. There was a lot of other issues there. So we ultimately did not settle up front. We did litigate the case. We were successful and we got him actually a bigger settlement at the end. But it's tempting. And insurance companies know that it's tempting. A lot of times they will throw money at you hoping that you're going to bite. It's the bait technique. You know, anytime an insurance company makes an offer, we're obligated to take it to our clients. And I always say that offer could be $10. I'm obligated to tell you about it and discuss the ramifications with you. And there are times where the insurance company will throw out an offer as undervalued as it might be, and the person just needs money. The insurance companies know that there are people out there that just need money and will take what's put in front of them, and it happens. It's important to have a good lawyer who understands what the value of your case might be, what the facts of your case are going to translate to in terms of dollar value in the long term. So you should have that discussion with your lawyer anytime there is an offer. What makes a big workers' compensation settlement? What type of injuries or circumstances lead to larger settlements? Cases are based upon the amount of money that you were earning prior to your accident, the severity of the permanent nature of your injury, and in some cases, lost time. So big injuries with high wage earners with a lot of lost time usually result in higher payouts. But it's not the hard and fast rule. As we've discussed in prior videos and prior live streams, schedule loss of use. A lot of times when you have a significant injury to an extremity, an arm, a leg, a knee, a shoulder, lost time is sometimes less of a factor. Sometimes you do better by going back sooner, regardless of how bad you need surgery. Because here in New York, a shoulder injury, the value is based on how bad that permanent disability is. Whether you go back to work or not doesn't change how bad your injury is. Shoulders, elbows, wrists, same for legs, hips, knees, ankles, things like that. But bigger injuries generally result in bigger settlements. Another factor is the extent and the type of treatment that a person will need moving forward. A major part of a settlement for an insurance company is buying out not just the money they're going to be forced to pay you into the future, but buying out your medical. Generally speaking, the vast majority of Section 32 settlements, the Section 32 settlement is a very popular, widely used settlement type, and it's a complete and total absolute closure of your case. The reason why insurance companies do that is they don't want to be on the hook for anything anymore. They want to close your medical out. So in circumstances where there is the prospect of a lot of future medical treatment that might be necessary, value will go up. And how that's dealt with varies from case to case. How are workers' compensation settlements typically calculated, and what factors have the biggest impact on the amount? So in order to determine the value of a settlement, we need to look at a few factors here. And first, it's like I just discussed, schedule loss of use versus non-schedule injuries. So the valuation of a head, neck, and back type of case is completely different from an arm or a leg. An arm or a leg, you're looking at the severity of the permanent damage to that body part. And as I said before, with schedule loss cases, we have the chart and everything kind of works off the chart. You look to the chart, You look to the medical treatment guidelines, you look to your client's specific injuries and limitations, and you figure out what the value is there. And obviously, as a claimant's attorney, we try to show that severity is as big as can be to try to get you as much money as possible. With non-schedulable injuries, head, neck, and back, the value is based upon the severity of your permanent disability and your lost time. You need to be out of work to get money on a case with a head, neck, or back, core body injuries, heart attacks and strokes are included in that, traumatic brain injuries and things of that nature. If you have the worst back injury in the world, but you go back to work and you're earning the same or more money than you were earning prior to your accident, generally speaking, you don't get money for that. At that point, we're trying to buy out medical if we're looking to settle your case. So oftentimes you have a combination. You might have a bad back and a bad neck and also a shoulder is included. You got to figure out which of the injuries has more value. And you got to look at whether or not the person's going back to work or has returned to work and where the value lies in the case. And also future medical care is factored in there. So there's a lot of factors in figuring out how a workers' compensation case is calculated, the value of a settlement. Are there different types of workers' compensation settlements and which one is right for me? So a permanent facial disfigurement award, that's a type of settlement. It could either be a settlement where we reach an agreement with the insurance company and settle the case. We could do a permanent facial disfigurement award via stipulation. And a stipulation is another type of settlement. It's a blank form. It's a form where we put the case information at the top and signatures at the bottom, and the middle is blank and wide open. And a stipulation form basically just means agreement. If the parties are able to reach an agreement, we write it on the form, we all sign it, the judge agrees and approves, the judge signs off, and boom, done. And a stipulation can address a minor issue in a case, amend to include the left pinky toe. Done. If everyone agrees to put it in, we could stipulate to it and put it in and be done with it. And we could also stipulate to 50% the scheduled loss of use of the shoulder and case closed, have a nice day. So a stipulation could address any one or a number of issues. It could address a small issue as a part of a case or a case in its entirety. A stipulated agreement, generally speaking, can be reopened under the proper set of circumstances if necessary. It's not an absolute total 100% closure like a Section 32 that we discussed earlier, which is a separate type of settlement. Whether that Section 32 addresses the whole case or part of the case, once that portion of the Section 32 is decided, approved, and closed, it's closed forever and cannot be reopened. The only way it can be addressed is if all the parties agree to reopen the case. But why is an insurance company going to agree to reopen a case that they paid to close? They don't want to ever see it again. So in reality, those cases are closed forever. How can injured workers increase the size of their settlement? Are there any strategies for getting a bigger payout? Get a lawyer. We know the law. We know the rules. We know the judges and the insurance companies. We know which insurance companies don't pay out, so we're not going to waste our time or your time. We know which insurance companies are a little looser with their wallets. We know how to convince people. Part of being a lawyer is being a negotiator. It's not just knowing the law, but it's knowing how to negotiate and apply the law and your facts all together and get you the best outcome possible. Nobody knows your story better than you. Nobody knows your facts and your circumstances better than you. But when you sit down with your lawyer and you tell them what's going on, they pluck out the things that they know are useful, and we use them to get you the best outcome possible. And one big thing, we hear about it all the time. People come in and they say, I need money. I haven't paid my rent in 2 or 3 months. I want you to tell the judge that I owe $12,000 in rent. Unfortunately, a judge is going to say, I'm sorry to hear that. That's horrible and I feel terrible. But there's nothing in the law that factors in the value of your rent in getting you more money. So that's a factor we're going to put aside. We're going to take what's important and what we could use to drive your case forward and get you more money. So getting a lawyer is probably the biggest thing for maximizing dollar value on a settlement of any type. Settling at the right time is also very important. And this goes back to getting a lawyer. We know when it's the right time to settle. Like I said before, most Section 32 settlements are full and final settlements. So not only are we settling the money portion, we're settling the value of your future medical care. As time goes on and as you get more and more treatment, that's less and less treatment that's going to be made available to you. So as time goes on, the value of your future medical goes down. So if you are getting ready to settle, you want to strike at the right time when you are presumably done for the most part with your treatment, but there's still some meat on the bone that you can get some value for future medical care there as well. So those are things that a lawyer is more familiar with and able to find the right time to settle your case. If you have questions about it, if you don't have a lawyer, you can give me a call, 212-406-8989. My name is Rex Sikowski, New York workers' compensation attorney. What if you get injured and cannot do the work you used to do? Does that help you with getting a good settlement? In workers' comp in New York, when we're talking about an overall level of disability, they look to your ability to do not your job, but any job. On the permanency form, on the C4.3, it's the name of the document that we use, there is a question on the form that says, can this person do their job, their at-injury job, with or without restrictions? Yes, no, and explain. And then the next question is, can they do any job with or without restrictions, and explain? So we're looking for a person's restriction from doing any work in New York State, their loss of wage earning capacity. The idea is how much loss of wage earning capacity is there? And that's from all jobs in New York State. But it certainly is a factor. If you certainly can't do your at-injury job anymore, it's something that will be considered. What should injured workers ask themselves before settling their workers' compensation case, and what should they consider before making their decision? The biggest thing that I tell my clients, whenever we talk settlements, where are you at with your treatment? Have you discussed this with your doctor? If we're going to settle your case, you need to know that more likely than not, your medical treatment is going to stop. If your doctor says, look, you could go home and I'll teach you how to do some stretches and you get an elastic band and you can stretch and help yourself at home, maybe settlement's a great time. If your doctor says that you need spinal surgery, well, maybe settlement's not such a good option at this point in time because we don't want to cut you off from your treatment. So having a discussion with your doctor and knowing where you are in the timeline of your treatment regimen is very, very important. Future medical care is a huge consideration. I always recommend that my clients, when we're getting into that point where we're negotiating a settlement, or maybe we've agreed to a number, or maybe we're signing papers, if you have a couple weeks before that case gets closed and finalized, go talk to your doctor. Get some home treatment exercises that are going to help you take care of yourself without your doctor so you don't have to pay them. Talk to your doctor about your need for medication. Medication is huge. The cost of medication is astronomical. We see Medicare set-asides come back, that sometimes they come back with these huge numbers, $100,000, $200,000, $300,000 for future medical care. And you look at the person and the injury, you're like, where's the number coming from? Medication. Medication is so expensive that if this person is needing to take medication for a very long period of time, those numbers blow up. They can blow up a settlement because they can get so big. So sometimes it's worth talking to your doctor about medication. Also, do you really want to be on medication the rest of your life? I'm not a doctor. I'm not giving medical advice here, but it might be a conversation you want to have with your doctor. Maybe quality of life, getting off medication, weaning your medication. It's worth at least having a discussion with your doctor. Do all injuries end with some sort of settlement? No, but we try to. There's a story from years and years ago. So we have IMEs. You go to see the insurance company doctor now. But back in the day, your doctor would file a permanency report. You say, Judge, here's my permanency report telling you what my client's doctor, what his opinion is on my client's permanent disability, his schedule loss of the arm. He has a 25% schedule. And the judge would look at the report and say, all right, go upstairs to the state doctor. He'd write out a little form and they'd send you upstairs to the state doctor, and the state doctor would do his own examination, very similar to an IME, and he would render his own opinion. And as the story goes, this particular client went upstairs and got the report from the state doctor, and the state doctor said that there was no loss of use. There was no permanent disability. And what the attorney did when she got the report, she said, sir, great news. You're fine. Go home. Because there wasn't going to be any money moving because they found no disability. So no, not every case ends with some sort of settlement. Some people get hurt and they get their benefits for their lost time and they get their medical treatment and they get better and they go back to work and they put it behind them. It's just a bad memory of something that happened and they move on. And also some cases, they're not all winners. The facts of a case lead it to the point of whether or not it's compensable or not. And if a case is found to be not compensable, they're not going to be a settlement. Any pro tips for injured workers settling their workers' compensation claim? Having a good doctor and a good lawyer is very important. A doctor who knows workers' comp, knows the forms, knows the law, knows how to do a schedule loss of use evaluation. Very, very important. We've dealt with people who are out of state and they go and see a doctor that's an out-of-state doctor, and we ask them for a permanency report, or we ask them for a schedule loss of use, or we ask for a comment on permanent disability, and we go and get a report back that reads like a different language because they don't know how to do a schedule loss of use evaluation according to the New York State rules. And it throws the whole case off. Having a doctor that knows the rules, having a good doctor that's going to get you to the point of maximum medical improvement, a high level of improvement, very, very important. Having a lawyer who knows how to apply those guidelines and the law, the facts of your case, also very, very important. Another thing that's important is having reasonable expectations. Talking to your doctor about what to expect from your treatment is very important. Some people think that they're going to get surgery and they're going to be like an 18-year-old who played soccer all over again because they got their knee fixed when they're 50 years old. You need to have reasonable expectations about what is to come from your treatment and what's to come from your case. Here in New York State, workers' compensation cases are not million-dollar cases. By its very definition, by the nature of workers' compensation, you're paid a portion of your salary. You don't even get your full salary. The goal behind the law is to get you the care and the benefits that you need to sustain you while you're getting better and get you back to work as soon as possible, not to maintain you for the rest of your life, unless it's absolutely necessary. Just the other day, I had a client in here, their medical report, their doctor's report would yield a payout of $5,400. The insurance company's permanency report would have gotten them, I believe, $500. So we're looking at $500 or $5,400. The insurance company offered them somewhere in the range of $4,000. And the person's response was, I want 10 grand. Well, we need to be realistic. We need to be reasonable. If the most I can argue for based upon your doctor's report is $5,000, why on earth would an insurance company give me 10? You need to be reasonable here. So that's very important. But if you have questions and if you don't have an attorney and you're looking for some help, feel free to give me a call. 212-406-8989. Rex Sikofsky, New York Workers' Compensation. We are here to help. Folks, thank you very much. Have a wonderful rest of your day. Enjoy the sun.